Hello again. My name is Douglas Pinkham of Pinkham and Associates. We are a dedicated family law firm here in Orange County, California. We also practice family law in Los Angeles, Riverside, and San Bernardino counties. If you have any questions, please send us an email. Look us up online. We are all over the internet. Look us up online and we'd be happy to assist you. Send us an email and get in contact with us and we'd be happy to talk to you. Okay, the next form I'm going to do is the responsive declaration to a request for order. This is a very, very common form. You're going to need to fill out this form when your counterpart, your opposing party in your case, your wife, your husband, or the mother of your child or father of your child, when somebody else fills out a form called a request for order, and they need to serve you with that, but when you get served, then you need to file this responsive declaration. Now, they're going to fill out and file their request for order when they're asking for custody, visitation, child support, spousal support, attorney's fees, whatever they're asking for, they need to fill this out if they ultimately want to go to court and ask a judge to make orders. This is how you get that hearing date. So this form is the responsive declaration to that form. So when somebody serves you with their requests, you need to pull up this form and you need to fill out this form. It's a pretty simple form. And remember, everything that we're marking off in this form, each box that we're marking or whatever, is going to correspond with something that the other party asked for in their request for orders. Okay, so just like every other form, up here in the header, you're going to put your name, address, city, state, zip, phone number. Down here, you're going to put your own name if you're representing yourself. Okay. Then down here, you put the county in which you're filing your form. And the address of the court all goes here. Then, of course, the petitioner's name, respondent's name, they're always the same. They never change. If you were the petitioner in the underlying divorce or paternity action, you're the petitioner throughout the entire case. Same thing is true with the respondent. If you were the respondent in the early case, then you are still the respondent. Then you're going to put the case number here, whatever your case number is. Then, if the other side served you with the RFO, their request for orders, if they served you with that paperwork, on that paperwork, there is a hearing date listed. So you need to put the hearing date there. Then the time of the case, say 8:30 in the morning, and the department in which the case is to be heard there. All right, so let's move on to the substance of the form. If there is a restraining order in your case, you need to mark 1 and mark a box. You can also mark 1 if there is no restraining order, because it says right here, no domestic violence restraining order or protective orders are now in effect between the parties in this case. Very simple. If there is a restraining order, then you're going to have to mark here that you agree that the 1 or more domestic violence restraining orders or protective orders are in place. In this case, I'm going to say there are no restraining orders. Then, the next box is important. It's custody and visitation. If you are dealing with actual custody, if the custody box is marked in the response, or excuse me, in the request for orders that you were served with, then you need to mark child custody. If it's only an RFO for visitation, then you don't need to mark custody, and you don't want to mark custody, but you will need to mark visitation and put in here. Now, in their request for orders, they're going to say what they want. They're going to say they want, every other weekend, 1 night during the week, whatever they're going to say they want for visitation. If you agree to what they're asking for, you simply mark this box. I consent to the order requested for child custody in the RFO. If you consent to the visitation plan that is put forth in the other party's request for orders, then you mark this box. If you do not agree and you want something else than what they're asking for, or you don't agree to what they're asking for at all, put I do not consent to the order requested for child custody or child visitation, And then you could put down here, but I do consent to the following order, and you can put in here what you want. And you can be as specific as you want. All right. Then down here, if they are asking in their request for orders, if they're asking for child support, then you're going to mark the child support box in which I have marked. And again, you're going to mark here. Oh, real quickly. A here, 3A says, if child support is an issue, then you absolutely must fill out, you have a duty to fill out an FL 150. It's an income and expense declaration. You will find a video on my website for the FL 150. So go look at that video. You need to fill out this form if this box is marked. So also fill out that FL 150, and you're going to need to file that with your responsive declaration. All right. So if they're asking for, let's say they're asking for $800 a month in child support. If you consent to that order, mark I consent to the order. If you don't consent to the $800 a month, but you do consent to a guideline order, whatever that may be, then you mark C. If you don't consent to the order requested, but you do consent to something else, you can again put it in here and mark what you want. Ellie? So then let's move on to box number 4, spousal support or domestic partner support. If the other party has marked the box for spousal support or partner support, you need to mark this box. And you need to do the same thing, whether you consent to it, don't consent to it, and why. So let's say you don't consent to it, but you do consent to something else. Okay. So now we're going on to page 2. On top of page 2, property control. So that would really come into play if, let's say, the other party is asking for like consented use for a house, or the consented use or a court order that they get to use a certain vehicle. Let's say they've asked for a court order that they want to be able to use both cars that you have. Some people even ask for that. Then obviously you would put, I do not consent to that, but I do consent to, say, each of us using the normal cars that we have always driven. Okay, sorry about that. My background may have changed just slightly. I had to plug in my computer. Okay, real life issues. All right, so we've finished number 5, property control. Now we'll go on to 6. Oh, and by the way, property control can be anything. It could be they're asking for the exclusive use of a boat. They're asking for the exclusive use of a particular bank account. You never know. If they're asking for something, they will mark property control, and they will mark and tell the court what they want. This is really a simple form. You're just going and reflecting off of what they're asking for in their request for orders. If they don't mark property control, then you don't have to mark that box at all. All right, then attorney's fees. If the other party is asking for an order for attorney's fees and costs in their request for order that they have served you with, then you mark this box. And again, if you consent to it, great. If you don't consent to it and why, then you mark those and you tell the court why. Okay? And down here, if there is a request for a domestic violence restraining order, you'd mark that box, number 7, and again, either you consent to it or you don't consent to it, and why. Okay? All right, so then on the request for orders form, there is a box called Other Orders Requested. If they mark that box, they're going to put something under there of explaining what other orders they want. If they do the exact same thing here. Either you agree to it or you don't agree to it, but you do agree to something else, or tell the court why not. All right, time for service. This is a technical request. If there is a very short time before the hearing and you're asking for the court to limit the amount of legal time that you need to serve this form, then you'd mark this box, or excuse me, I beg your pardon. If in their RFO they are requesting a change in the amount of time that they need to serve you, let's say they're asking to serve you within 5 days before the hearing. If you agree to that, then you mark I agree. If you don't agree to that, you mark this one and you say why, just like all the other ones. Okay, so, and down here in 10, this is where you put the facts in support of your responsive declaration. Now, I'm here to tell you, the judges they will never admit to this, but it is my firm belief, after doing this for 18 years or more, that the judges read our paperwork in their chambers and oftentimes make a decision before they even come out to the court, before they even hit their bench. They've already mostly made up their decision. And they do that by reading the paperwork and reading the declaration from the moving party and your responsive declaration. So this box that I have highlighted in yellow is the most important part of your paperwork. You absolutely must explain to the court why you want what you want and why you disagree with what the other side is asking for. Almost invariably, it does not fit in this box. So you're going to want to write your declaration in an attachment and then attach it to this paperwork. All right, so however you do it, make sure that it is thorough. You want to make sure the judge understands everything. Okay, and by the way, you don't want it to be 10 pages long, but it can be up to 10 pages long. You do not want a 10-page declaration. I'll just tell you up front, I doubt a judge would even read a 10-page declaration. So keep it, you want to be thorough, but keep it, concise. So 2-3 pages would be, more than I would suggest. Okay, or about what I'd suggest. Okay, then simply put the date here, you write your name here, and you sign your name over here. Keep in mind, when you sign this form, you are signing under penalty of perjury that everything you wrote here and everything you wrote in your declaration is true and correct. All right, folks. Again, my name is Doug Pinkham with Pinkham & Associates here in Orange County, a dedicated family law firm. All we do is divorce and family law. And also keep in mind, if you need help with this particular form or any other form, we always provide a very affordable flat rate fee to help you fill out these forms and get it done right the first time. Many of these forms have other forms that you have to attach with it. Like for example, this form requires an income and expense declaration if there are any financial requests being made, child support, spousal support, attorney's fees, costs. So in those cases, there's other forms that are needed. If you have children, you're going to need to do the UCCJEA form. And you can see another video where we've discussed the UCCJEA form. But if you have a need to have us help you fill out your paperwork, we can certainly do that for you. Thank you very much, and good luck with your case.